All right, looks like everything's good. Well, greetings, everybody. Today we're going to be going over the constitutional law, part 4, which is going to be focusing on the supremacy of the United States Constitution and its amendments included, how these all apply. And in a moment here, I'm going to pull up again, we're using Black's Law 9th Dictionary to address any of the terms that we might need to look up. And let's get started here. Oops, wrong one. There we go. All right. So, the supremacy of the United States Constitution and amendments thereto. The Constitution of the United States and any amendments thereto, together with laws made in pursuance thereof, and treaties made under the authority of the United States, are expressly declared to be the supreme law of the land. So we have a constitution, amendments, laws made in pursuance thereof, and treaties made under the authority of the United States are expressly declared to be the supreme law of the land in the Constitution itself. The Constitution, as a supreme law, is without qualification and is absolute. And the powers actually granted constitute the paramount authority of the land. So the Constitution is the top paramount authority of the land. We see this iterated several times. I think they're trying to make this point clear. The federal Constitution is binding on all officers and departments of both the federal and state governments. I find this kind of interesting if you notice the capitalization of the word federal here and the lack of capitalization on the word federal here. So when they are saying the federal Constitution with a capital F, I believe they're referring to the United States, not the United States of America, but the United States as a federal corporation. And I think with the capital F, when they say the federal Constitution, I believe that's in place of saying United States Constitution. But I can't say for sure. We need to read a little bit further to find out, but I find this interesting that the lack of capitalization over here, it should be here as well, right? It says the federal, and here it also says the federal. So I just want to point that out. So let's read this again. The federal Constitution is binding on all officers and departments of both the federal and state governments. So the U.S. Constitution is binding on all officers and all departments of all state governments, federal governments. So the Constitution is binding for them as well, including every court, whether it derives authority from a state or from the United States. So, again, the U.S. Constitution is the supreme law above all others. No other qualification is needed. Neither a statute nor a treaty can override the Constitution. Now, again, it says here, in treaties made under the authority of the United States. But it says here, a treaty cannot override the Constitution. So, let's keep this in mind. The only conflict is that if there is a conflict between the treaty and the Constitution, then it seems that the Constitution would prevail. State laws that run contrary to constitutionally protected rights of individuals. Individuals can refer to individual men and women, could be individual groups of people, companies, etc. too. So individual depends on a definition, and I believe in this context, which we could probably check with blacks just to make sure, because words like this can frequently be overlooked, and I'd like to not do that in this particular situation here. So let's look up individual, and see what we get in Black's Law if we could pull up a good definition of it here. Wow, okay, I gotta get down a ways here. Individuals used a lot throughout here, and it's not gonna pick up just a word when I search here. So bear with me for just a moment until I pull up the right page. Here we go. This should be closer. No. Okay, we're getting close here. Here we go. So that's page 871. Okay. Individual. Existing as an indivisible entity of or relating to a single person or thing, as opposed to a group. So, okay, there we go. So it's not a group. An individual is an indivisible entity. I guess that could be a company too, but it would not be considered a group as an individual. Let's continue. State laws that run contrary to the constitutionally protected rights of individuals, not of groups, cannot be allowed to stand and are without effect. No state law or public policy of a state can be allowed to override the positive guarantees of the federal Constitution. Thus, the Constitution of the United States will trump state rules of evidence. Did you see this? This is important. No state law or public policy of a state can be allowed to override the positive guarantees of the federal Constitution. That means there's constitutionally protected rights of individuals cannot be allowed to stand and are without effect. pretty forceful words here. Just want to check and see if there's people here in the chat and that I'm coming through here clear, because I'm trying to make sure I'm keeping up with any questions people may have. All right, let's continue here. Thus, the Constitution of the United States will trump state rules of evidence. Furthermore, where the national and state constitutions conflict irreconcilably, the latter must yield under the Supremecy Clause. And that's footnote 17. So we see this with the national and state constitutions conflict irreconcilably, meaning they cannot figure a way to agree upon the conflict to resolve it. The latter must yield. That means the state constitution must give up, must yield under the Supremacy Clause. And provisions in state constitutions are held void as inconsistent with federal constitutional provisions. So provisions, things that the state constitution provides for, if they're in conflict with the federal constitution, they are held void as inconsistent with the federal constitution. So some important aspects here. We have both state rules of evidence that cannot be overridden in the federal constitution, and the protection of individuals' rights applies without okay, so we also have provisions from state constitutions are held as void if they are in conflict with constitutional provisions. However, a federal court will defer to a state court's interpretation of its own state constitution, though. So now, if you are at, this is very important for a particular kind of case, and that's why it's so valuable to read American jurisprudence to understand all the pitfalls of all the possibilities, just like our Constitution was a document written that the founders could not foresee, not even contemplate the possibilities of the future that that document had to endure. So when you're approaching these types of cases in the court, in this scale, much smaller scale, it's still the same type of approach. You want to make sure that there's things that are you don't even think of or contemplate or foresee that you still have to have provisions for so that you don't fall into the pitfalls of a losing case. So here's an important aspect I wanted to point out, that a federal court will defer to a state court's interpretation of its own state constitution. So let's think about this for a second. If you had a problem with your state, a law from your state's constitution, and you found it to be unconstitutional with your own state's interpretation of, say, federal rights or what have you, if your case is only presented to be in dispute of your state's constitution and you take it to federal court, your the defendant for the state would be able to argue that, the state court's interpretation was this way and that the federal court has no authority to override that. So it's an interesting perspective to consider. Whether or not this might apply to you at this particular time or not, the fact is that if you're a well-rounded law practitioner, you'd have a deep understanding of these situations so that if they do arise, you immediately can understand the complete ramifications of what's involved when you go from one jurisdiction of a court to another. All right, let's continue. Under the Supremacy Clause, Congress has the power to preempt state law expressly. On the other hand, powers granted to the federal government in the Constitution cannot be exercised in such a way as to have the practical effect of nullifying important state powers expressly reserved to the states in the Constitution. And the Supremacy Clause only operates to the extent that there is an actual conflict between state and federal laws. Thus, the states retain substantial sovereign powers under the constitutional scheme, and Congress does not readily interfere with them. So let's unpack this a bit. This is a pretty interesting way of approaching state law and the Supremacy Clause. So under, under the Supremacy Clause, Congress has a power to preempt state law expressly. So it would be a way of them to prevent a state law from happening. But on the other hand, the powers granted to the federal government in the Constitution cannot be exercised in such a way as to have the practical effect of nullifying important state powers expressly reserved to the states in the Constitution. So if Congress does pass a law that would preempt another state law from being expressed, that would stand. However, the powers granted to the federal government cannot be exercised in such a way as to have the practical effect of nullifying. So if a law is passed to keep perhaps state laws in compliance or in conformity with our Constitution, it cannot be shown to have a practical effect of nullifying important state powers that are also reserved to the states in the Constitution. So the Supremacy Clause only operates to the extent that there's an actual conflict between the federal and state laws. So this makes a lot of sense. Thus, the states retain substantial sovereign powers under the constitutional scheme, and Congress does not readily interfere with them. So, in other words, Congress is not going to get involved with state constitutions until there's a direct conflict. And if they're doing anything to preempt, it can't be done with a practical effect of nullifying a state power that's already reserved for the states within the Constitution. All right, let's continue. All courts, federal and state alike, take judicial notice of the provisions of the United States Constitution. Now, this is a great statement here. And we have footnote 24, so let's get right to it. Let's look through here real quick on the way to 24. Time Warner, it's 1995, as to the Supremacy Clause. Interesting. And just looking down here to see 24. Here we go. Ben Miriam versus Office of Personal Management. 86. And then we also have around 6th Circuit, 1993. Okay. So these are pretty old cases there. I mean, considering. All right. Effective emergency. Before we get here, there's one thing I did want to look at really quick. Now we've had the introduction here. And that's the effect of new Constitution or amendment thereto on common law. Now that we've had an overview of what we mean by the supremacy of the Constitution, let's think about how this applies to common law. And then we'll continue. Constitutional rights prevail over common law rights. Now, look at this. Constitutional rights prevail over common law rights. And constitutional mandates supersede contrary common law rules and statutes. Thus, common law rights existing in equity may be superseded or abrogated by a state in its constitution. So let's break this apart. I'm not going to pretend like I fully understand this now, so let's read this one more time. Constitutional rights prevail over common law rights, okay, and constitutional mandates supersede contrary common law rules and statutes. So a constitutional mandate will supersede common law rules and statutes. In other words, case precedents and such, previous rulings. Thus, common law rights existing in equity. So let's break this down here. What do we mean by existing in equity? And that's a good question so we can break down these words a bit better. Equity is a common word to hear these days, and we talk about equity in a matter of a legal context. It becomes a little bit different, and we're going to get into that right now. We're going to go down this quick rabbit hole. If you give me just a moment to find it. Jeez. Okay, here we go. Wow, we could really go off on this one for a while. There's a lot of pretty fun. Jeez. All right, 647. If there's anyone here that hasn't already, please hit the like. Okay, equity. Noun from the 14th century. Fairness, impartiality, even-handed dealing. The company's policies require managers to use equity in dealing with subordinate employees. 2. The body of principles constituting what is fair and right. Natural law, the concept of inalienable rights, reflects the influence of equity on the Declaration of Independence. Let's read this here. In its popular sense, equity, is practically equivalent to natural justice. But it would be a mistake to suppose that equity, as administered by the courts, embraces a jurisdiction as wide and extensive as that which would result from carrying into operation all the principles of natural justice. There are many matters of natural justice wholly unprovided for from the difficulty of framing any general rules to meet them, and from the doubtful wisdom of a policy of attempting to give a legal sanction to duties of imperfect obligation, such as charity, gratitude, and kindness. Look at that. So there are many matters of natural justice wholly unprovided for, from the difficulty of framing any general rules to meet them, and from the doubtful wisdom of a policy of attempting to give legal sanction to duties of imperfect obligation. Imperfect obligation, such as charity, gratitude, and kindness. That's called imperfect obligation. A large proportion of natural justice, in its widest sense, is thus not judicially enforced, but is left to the conscience of each individual. A large portion of natural justice is not judicially enforced, but is left to the conscience of each individual. 3. The recourse to the principles of justice to correct or supplement the law, as applied to particular circumstances. The judge decided the case by equity because the statute did not fully address the issue. Also termed natural equity. And we could also look at equity here. So 4. The system of law or body of principles originating in the English Court of Chancery and superseding the common law and statute law, together called law in the narrower sense, when the two conflict. In appealing to the equity of the court, she was appealing to the king's conscience. Chancery. So let's read this a little bit in detail. Yikes, because I'm not going to elaborate more on this. Let's see what they have to say here in Black's, this quote. This comes from The Principles of Equity, 1931, Joseph D. McCoy. Equity is that system of justice which was developed in and administered by the High Court of Chancery in England, the exercise of its extraordinary jurisdiction. This definition is rather suggestive than precise, and invites inquiry rather than answers it. This must necessarily be so. Equity, in its technical and scientific legal sense, must neither natural justice nor even all that portion of natural justice which is susceptible of being judicially enforced. So, you get this? It means neither the natural justice, equity. It doesn't mean natural justice, not even a portion of natural justice which is susceptible to being judicially enforced. As we read before in the definition, is that it can't be judicially enforced. So what can be still doesn't define equity, even the parts that can be. So what is it? It has, when employed in the language of English law, a precise, definite, and limited signification, and is used to denote a system of justice which was administered in a particular court, the nature and extent of which system cannot be defined in a single sentence, but can be understood and explained only by studying the history of that court and the principles upon which it acts. In order to begin to understand what equity is, it is necessary to understand what the English High Court of Chancery was and how it came to exercise what is known as its extraordinary jurisdiction. Every true definition of equity must, therefore, be, to a greater or lesser extent, a history. So the context, historical context, is the only way to understand the concept of history. Let's continue. In its technical sense, equity may be defined as a portion of natural justice, so not all of natural justice, but we can say equity is one portion of natural justice which, although of a nature more suitable for judicial enforcement, was for historical reasons not enforced by the common law courts, an omission which was supplied by the Court of Chancery. So, equity is a portion of natural justice. It needed to be enforced. It wasn't being enforced judicially for historical reasons by the common law courts. So that omission was supplied by the Court of Chancery. So it became part of the jurisdiction, I guess, of the Court of Chancery. In short, the whole distinction between equity and law is not so much a matter of substance or principle as of form in history. Interesting. So that comes from Megary's Snell's Principles of Equity, too. The term equity is an illustration of Mr. Tokington's proposition that some words have a legal meaning very unlike their ordinary one. Oh boy, let's read this again. Proposition that some words have a legal meaning very unlike their ordinary one. In ordinary language, equity means natural justice. But the beginner must get that idea out of his head when dealing with the system that the lawyers call equity. Originally, indeed, this system was inspired by the ideas of natural justice, and that is why it acquired its name. But nowadays, equity is no more and no less natural justice than common law, and it is, in fact, nothing else than a particular branch of the law of England. Equity, therefore, is law. The student should not allow himself to be confused by the lawyer's esquire's habit of contrasting law and equity, for in this context, law is simply an abbreviation for common law. Equity is law in the sense that it is part of the law of England. It is not law only in the sense that it is not part of common law. So this is 1982, Learning the Law by Williams. So this is a pretty interesting quote here. And let's just reread this last statement. Not that any of us are law students, or this is definitely not any kind of law or legal advice, and I have no expertise to give advice, nor am I intending to. This is strictly just for a review of American jurisprudence. Let's read this one more time. The student should not allow himself to be confused by the esquire's habit of contrasting law and equity. For in this context, law is simply an abbreviation for common law. So in that context of contrasting law and equity, you're really contrasting common law and equity. And as we learned here from the historical context, it's just a historical omission of equity from common law, and that omission was taken up by the Court of Chancery instead. But we don't have that division of courts here like that, so therefore equity is law in the sense that it is part of the law of England, lowercase. It is not law only in the sense that it is not part of common law. So it's not law only in the sense it is not part of the common law. So it's law, but it's not common law. And the true law of everything together is common law plus equity. So in this context, it's a historical context. So it's not something you can explain to somebody in one sentence. It's not something you would explain to a judge in one sentence. But from the construction of your arguments, you could weave this type of historical wisdom into your arguments, because equity is law And as we might not have specific courts of equity, those elements have to be part of the law because without them, they have to be taken up somewhere. So therefore, they are just embodied to the rest of our laws. Supposedly. Let's continue. 5. A right, interest, or remedy recognizable by a court of equity. There was no formal contract information, so they sued for breach in equity. So we get back in other kinds of equity. Look at this kinds of equity we get. Let's read a few of these. Contravening equity. That's a right or interest that is inconsistent with or contrary to a right sought to be enforced. So look at this. A right of interest that is inconsistent or contrary to a right sought to be enforced. Then we have countervailing equity, a contrary and balancing equity, equally deserving of consideration. There's latent equity. That's an equitable claim or right known only by the parties for and against whom it exists, or that has been concealed from one who is interested in the subject matter, also termed secret equity. Perfect equity. Let's see, I said negative equity, the difference between the value of an asset and the outstanding amount of the loan secured by the asset when the asset's current value is less than the loan's balance, negative equity. Then we have it down here, 8, an ownership's interest in property, market equity, equity accounting method, equity capital, equity contra legem, equity contra legem. International law, the use of equity in derogation of the law, where, under the circumstances of the case, an exception to the law is needed to achieve an equitable and just result. An exception to the law is needed. Wow. Sometimes shortened to contra legem. Equity financing, equity insolvency, equity intra legem, a court's power to interpret and apply the law to achieve the most equitable result, sometimes shortened to intra legem. Also written equity infra legem. So this is an interesting thing here, infra and intra, but intra legem is a court's power to interpret and apply the law to achieve the most equitable result. So you can make a motion for equity intra legem because perhaps there's an unbalance of power, and the laws to achieve the most equitable outcome would need some type of court's interpretation that would be outside of a standard one. Equity jurisdiction, equity jurisprudence, equity kicker, equity loan, equity exoneration, the right of a person who is secondarily liable on a debt to make the primary. Okay, so equity of partners. So equity really is a deep concept, and that's why we spent so much time to dwell on it. Equity pleading, equity of the statute rule, equity participation, equity praeter legem. What's this one? The use of equity to fill a gap in the law, sometimes shortened to praeter legem. Equity ratio, equity security, equity to a settlement, term, stock. All right, so we get a lot of financial terms and then equivalents and patents. All right, so that's a nice deep dive into equity. And if you are a law student, I wonder if you would take that deep of a dive. Did I lose everyone? I'm glad everyone's staying with me on this. Okay, let's continue here. Constitutional rights prevail over common law rights, and constitutional mandates supersede contrary common law rules and statutes. Thus, common law rights common law rights existing in equity may be superseded or abrogated by a state in its constitution. Wow, that's kind of interesting here. So again, remember the equity is the law. Common law is part of law. Equity is part of law. So common law rights existing in equity may be superseded or abrogated by a state in its constitution. However, constitutional provisions do not repeal the common law by implication unless the intention to do so is plain. The framers of the Constitution are presumed to have intended no change or innovation in the common law further than what appears from the express declarations or reasonable implications. And the common law is repealed by such constitution to the extent that is inconsistent therewith, and only to that extent. So only inconsistencies between the common law and the Constitution are presumed to have, any there can be no repeal of the Constitution by common law. Jural rights, which were so well established prior to the adoption of a Constitution, are preserved by the Constitution and may not be abolished by the legislature. So jural rights. What are jural rights? I'm not too sure. We're going to find out in just a moment in our trusty Black's Law. Let's see, jural. Here we go. Oh, shoot. Hang on a second. Jural. Jural, 17th century adjective, of or relating to law or jurisprudence. Legal. So we get jural and equitable rules. Okay. So remember, law or jurisprudence and then equity. Of or relating to rights and obligations. The name of jural. So sweet a jural agent is, or jural an official, 2004. Common law examples include judges, legislatures, and police officers acting in their official capacities. Interesting. Common law examples of jural agents, an official, someone who has the appropriate authoritative status in society to enforce or affect the society's legal system. Wow. Who engages in a jural act. In a jural act, see under act, which we will. Common examples include judges, legislators, and police officers acting in their official capacities. So we need to look up act. Come on. Jural act, here we go. An act taken is 1860. An act taken in the context of or in furtherance of a society's legal system. In order to identify an act as a jural act, it must be the kind of act that would be engaged in by someone who is enforcing the law, enforcing a law, determining an infraction of the law, making or changing a law, or settling a dispute. So an act is a jural act. It must be a kind of act that would be engaged by someone who is enforcing a law, engaged by someone who is determining an infraction of the law, like maybe a magistrate, or making or changing a law, legislator, or settling a dispute, which could be any kind of a judge, really. Philosophy of Law, Martin P. Golding, 1975. All right, so now we learned about jural and jural acts and those that are taken to jural activities. Let's continue. So jural rights, which were so well established prior to the adoption of a constitution, are preserved by the Constitution and may not be abolished by the legislator. So there's rights, jural rights, that are established prior to the Constitution but are adopted. But are preserved after the adoption. So they were established prior to and are now preserved by the Constitution and are not to be abolished by the legislature. And that's footnote 7. So let's see this. 1968, Kentucky Utilities Company versus Jackson County Rural Electric Co-op Corporation. Kentucky, 1968. Interesting. All right, this is where we left off before. So I want to get back to that because that part there was the historical context. That's really going to aid us in the further of our studies here. And here we go. Supremacy of the United States Constitution and amendments thereto. Effective emergency. All right. This is a really juicy part. We still have people here. I want to make sure everyone's here. If you need to get a drink or something, take care of that and get back because this is the fun part. Okay. An emergency, while it cannot create power, increase granted power, or remove or diminish the restrictions imposed upon the power granted or reserved, may allow the exercise of power already in existence, but not exercised, except during an emergency. Did you get this? An emergency cannot create power, increase granted power, or remove diminished restrictions imposed by the power granted or reserved. But it may allow the exercise of power already in existence, but not exercised, except during an emergency. So there are powers that are reserved for the emergency, basically. The danger must be immediate and impending, or the necessity urgent for the public service, such as will not admit of delay, and where the action of the civil authority would be too late in providing the means which the occasion calls for. For instance, there is no basis on the Constitution for the seizure of steel mills during a wartime labor dispute, despite the President's claim that the war effort would be crippled if the mills were shut down. All right, footnote 3. That was Youngstown Sheet and Tube Company versus Sawyer, and that was Ohio, 1952. Well established. The Supreme Court has not denied the reality of dangers from foreign or internal conflicts. Rather, it has recognized the need to respect constitutional requirements even in troubled times. Security interests may be affected by fluctuations in international trade and the supply of natural resources, by social unrest at home and abroad, by the public disclosure of policy deliberations. However, such events cannot routinely justify invasions of privacy or restrictions on expression without devaluing and eventually destroying those rights. Do you hear this argument? Security interest. Okay, they may be affected by fluctuations, blah, 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 but such events, so we could say security interests cannot security interests cannot routinely justify invasions of privacy or restrictions on expression without devaluing and eventually destroying those rights. So when someone claims security interest is a justification for invading your privacy or restricting your expression, in effect, what it really is doing, it can't do that thing on a limited aspect without devaluing and eventually destroying those very rights. Nonetheless, the court has recognized that authority of an emergency nature to protect national security information is vested in the President as head of the executive branch and as Commander-in-Chief. So, that's footnote 5. Department of Navy versus Egan, 1988. 88. What was going on? Emergency. Must be around that Desert Storm thing, right? No, that's preceding that. Interesting. Okay, let's continue. Supremacy of federal laws made in pursuance of the United States Constitution. The supremacy of federal court decisions. The United States Constitution provides that the laws of the United States made in pursuance of the Constitution are the supreme law of the land. Anything in the Constitution or laws of any state to the contrary notwithstanding. Preemption of state laws occurs through the direct operation of the Supremacy Clause. The Supremacy Clause creates a rule of decision under which the courts must not give effect to state laws that conflict with federal laws. That's a rule of decision. You want to move for the court to see that rule of decision. Move on that rule, okay? So therefore, in those areas where the Constitution grants the federal government power to act, the Supremacy Clause dictates that federal enactments prevail over competing state exercises of power. In other words, the Supremacy Clause. Under the Supremacy Clause, federal law preempts contrary state law. We were reading this before, so let's see the detail here. Hence, state laws that conflict with federal law are without effect. Also, a state law is void if it is contrary to a valid act of Congress and is without effect, since Congress clearly has the power to preempt state laws. In fact, by reason of the Supremacy Clause, Congress has virtually unfettered power to preempt state law. Federal statutes operate essentially as a part of the law of each state and are as binding on its authorities and people as are its local constitution and laws. And federal statutes are controlling over state constitutional or statutory provisions. Also, state policies or regulations and orders of state administrative agencies may not prevail where they conflict with valid enactments of Congress. When federal law forbids an action that state law requires, state law is preempted. Thus, state laws are always subordinate, and federal laws enacted pursuant to the Constitution are always paramount. Okay, I want to make sure everyone's still with us here. Right. Great. Let's see if make sure stuff's all woken up here on the computer side here. Yep. All right. Now we're getting back up here. All right. I'm back online. Just want to make sure. Yeah, pomegranates are great. All right. Let's continue. The Supremacy Clause may entail preemption of state law either by express provision, by implication, or by a conflict between federal and state law. So we've been over this a few times. We should be very clear. It's either by express provision, implication, or conflict between state and federal law. Under the Supremacy Clause, the criteria for determining whether a state law has been preempted by an act of Congress, therefore, are whether, here's our checklist here, to determine whether state law has been preempted under the Supremacy Clause. So Congress, in enacting a federal statute, expressed a clear intent to preempt state law. So it may entail preemption, determine whether it's been preempted. Okay, so here are the ways we can preempt it. Congress, in enacting a federal statute, expressed a clear intent to preempt a state law. I get it. So they passed a federal statute to prevent the threat, let's say, of a state passing a law that would be unconstitutional or otherwise not valid. There's an outright or actual conflict between the federal and state law, which we are clear about, it is physically impossible to comply with both federal and state requirements. There is implicit in the federal law a barrier to the state regulation. Congress has legislated comprehensively, thus occupying an entire field of regulation and leaving no room for the states to supplement federal law. So that's when Congress has comprehensively occupied that field of regulation. There's no room for states to supplement that. So anything they would have would either be in compliance or in conflict with it. And if it's in conflict, it could be preempted by the act of Congress or the Supremacy Clause in general. The state law stands as an obstacle to the accomplishment and execution of the full objectives of Congress. Great. All right, now we get to the fun stuff here, the practice tip. When attempting to determine whether a federal statute preempts a state statute, the question an attorney or court must ask, which is basically a question of congressional intent, is whether Congress, in enacting the federal statute, intended to exercise its constitutionally delegated authority to set aside the laws of a state. If so, the Supremacy Clause requires a court to follow federal, not state law. So if it was the intent of the Congress, right, to exercise its authority to set aside the laws of a state, then the Supremacy Clause requires a court to follow the federal, not the state law. That's your practice tip. So if you can argue either way, but the court is going to follow the Supremacy Clause in this case, and it would be, the precedent would be for federal, not the state law. State courts are bound by decisions of the United States Supreme Court as to federal law or the Constitution. Although there is authority to the contrary, some jurisdictions adhere to the view that a state court is not bound by the decisions of a federal court other than the United States Supreme Court, even though a federal question is involved. State courts are not bound to follow a decision of the federal court, including the United States Supreme Court dealing with state law. However, where federal and state statutes are similar and are intended to accomplish the same objectives, state courts, in construing the state statutes, will be strongly inclined to follow federal court construction, especially where state law was purposely modeled on the corresponding federal statute. So that comes into the law writing process, how well it was done within that state. In our footnotes, we have from the U.S. Constitution, Article 6, Clause 2. That's footnote 1. This is a long chapter, so I appreciate everyone sticking with me on this. The United States Constitution provides the laws of the United States made in pursuance of the Constitution are the supreme law of the land. Anything in the Constitution or laws of any state to the contrary, notwithstanding. That's in Article 6. And we have, let's see here, anything else in here? Oh, look at this. Railroad Friction Products Corporation. You got some of these old, you'd think it'd be an older one, you know, they're 2012. Here's Armstrong versus Exceptional Child Center, 2015. Some interesting cases to look up here, I bet. As to the supremacy of federal administrative rules and regulations, Milk Control Commission, wow. Penn Dairies versus Milk Control Commission of Pennsylvania, 1943. I bet that's an interesting one. Look, Rice versus Board of Trades of City of Chicago, 1947. Interesting stuff here. Palm Wonderful LLC versus Coca-Cola, 2014. Footnote 19. What were they referring to here? So these are great case precedents that are set. The question is a preemption case is whether state law is preempted by federal statute. Wow. So there must be a conflict or something like that, or a federal statute that was. So these are the cases where you'll find the text of these cases. Some interesting stuff. You have State of Florida versus Mellon, 1927. So lots of good cases. This was a long chapter, so I appreciate everyone staying with me along here. A lot of railroad companies in this. Mazda Motor versus Williamson. Is that Florida? No. Connecticut. Affiliated Tribes, Fort Berthoud Reservation versus Wold Engineering, 1986. Yeah, so we got a lot of interesting thing here. Affiliated Tribes of Fort Berthold Reservation. Oh, sorry, 3 affiliated tribes. So this would be an interesting case here, 1986. All right, and we're getting down to the next section here. And the supremacy of federal administrative rules, regulations, and determinations. So let's get through this one here. This isn't too bad, I don't think. All right. Federal regulations have no less preemptive effect than federal statutes. By the way, preemptive, let's look at that word for everyone because I don't want to leave anyone behind. We've been seeing this word way too much. Let's not have a deep definition of it. I think this is it, 1325. Come on. Oh, wait. Okay. Did I miss it? Yeah, here it is. Preemption. 18th century. Noun. The right to buy before others. The right of preemption. Okay. 2. The purchase of something under this right. Constitutional law. Here we go. The principle derived from the Supremacy Clause. Yep, here we are. That a federal law can supersede or supplant any inconsistent state law or regulation, also termed, in sense, federal preemption. All right, so we got it. So we found the definition that directly applies to what we're talking about here. The question is whether state law is preempted by federal agency action. In the case of a conflict between the regulations and order of a state commission on a subject properly within the jurisdiction of a federal agency or commission which has acted on the subject by issuing its own regulations or orders, the former must yield to the latter. So, state commission on a subject poorly written, state commission on a subject properly within the jurisdiction. So regulations and orders of a state commission on a subject properly, right? There's a conflict between regulations on a subject properly within the jurisdiction of a federal agency or commission which has acted. So you've got to read these things sometimes a few times through because they're very complex sentences. Let's make sure we're associating the right parties here. So we got, in case of a conflict between the regulations and orders of a state commission on a subject that's properly within the jurisdiction of the federal agency or commission which has acted on this. Okay, so the federal agency or commission has acted on the subject by issuing its own regulations or orders. The former must yield to the latter. So the state commission must yield to the federal agency or commission. Since the term laws of the United States, as used in the Supremacy Clause, encompasses both federal statutes and statutorily authorized federal agency regulations. So codes of federal regulations also apply. All right, let's continue here. A ruling of a federal agency that has jurisdiction in a particular matter may thus thus preclude a state agency from taking jurisdiction. And state courts are bound by the lawfully authorized acts of the federal agency. So it could preclude a state agency from taking jurisdiction, which would essentially prevent standing in the case, it seems. All right, give me a second here. I just want to make sure everyone's still with me here. And all this stuff is still working properly here on this end to the YouTube land. And if anyone's still in here, please hit the like. All right, we're going to try and finish up this chapter here, and then we're going to take a break from the constitutional law, as this is a very long document. Okay, so a ruling of a federal agency that it has jurisdiction in a particular matter may thus preclude a state agency from taking jurisdiction, and state courts are bound by the lawfully or authorized acts of the federal agency. Furthermore, federal regulations may preempt established policies concerning the application of state statutes that conflict with federal mandates. Where state and federal authorities have concurrent powers, orders, and the regulations of state administrative agencies may operate so long as Congress has not preempted the field by its own enactments. So, state and federal authorities have concurrent powers, orders, and regulations of state administrative agencies. Concurrent powers, orders, and regulations of state. Federal authorities and state authorities, right? State and federal authorities have concurrent powers, orders, and regulations of state. Administrative agencies may operate so long as Congress has not preempted the field by its own enactments, and where state regulations are not at variance with the federal regulations. However, where the United States exercises its power of legislation so as to conflict with a regulation of the state, either specifically or by implication, the state legislation becomes inoperative and the federal legislation exclusive in its application. Express preemption exists where a federal regulation contains explicit language indicating that a specific type of law is preempted. So express preemption exists when a federal regulation contains explicit language. Express preemption, explicit language indicating that a specific type of state law is preempted. So express preemption requires explicit language indicating that the specific type of state law is preempted. Field preemption exists where a scheme of federal regulation is so pervasive as to make a reasonable inference that Congress left no room for the states to supplement it, to add to it. Accordingly, under the Supremecy Clause, even in the absence of express preemptive language, Congress's intent to preempt all state laws in a particular area may be inferred where there is a need for uniformity, or where the scheme of federal regulation is sufficiently comprehensive as to make a reasonable inference that Congress left no room for supplemental state regulation. Conflict preemption occurs when a compliance with both federal and state regulations is a physical impossibility. So conflict preemption, remember that's one of the preemptions that's permitted for the Supremacy Clause to nullify a state regulation. So if the federal and state regulations is that the compliance with both of them is a physical impossibility. So think about this. That's called a conflict preemption, or where state law stands as an obstacle to the accomplishment and execution of the full purposes and objectives of Congress. So again, state laws that occur in such a way that to have compliance with them and with the federal regulations at the same time, it's being a physical impossibility would make them nullified and void. So that's one way to nullify a state law or regulation, a state regulation, if it's in a physical impossibility to be in compliance with both those regulations. Okay? While federal agencies have no special authority to pronounce on preemption issues absent delegation by Congress, they do have a unique understanding of the statutes that they administer and an attendant ability to make informed determinations. Remember, determinations are considered final decisions in law about how state requirements may pose an obstacle to the accomplishment and execution of the full purposes and objectives of Congress. Purposes and objectives. Purposes have to be defined here. Whenever you're trying to find out about execution, right, of the requirements, would require a purpose and objective of Congress. State statutes, as well as municipal ordinances, may be rendered inoperable and unenforceable, suspended or preempted to the extent to which they conflict with valid regulations or orders of federal administrative agencies. Federal administrative agencies can supersede these municipal ordinances. So state statutes as well as municipal ordinances may be rendered inoperable and unenforceable. This happens quite a bit, and we can see here two footnotes, 21 and 22, or suspended, preempted to the extent to which they conflict with valid regulations. So they can be suspended to the extent they conflict with the valid regulations, or preempted, or orders of federal administrative agencies. Okay. However, it should never be presumed that Congress intends to supersede or suspend the exercise of the reserved powers of the state, even when that may be done, and except so far as its purpose to do so is clearly manifested in the statute under construction, as an order of a subordinate agency should not be given precedence over a state statute, otherwise valid unless it conforms to a high standard of certainty. So furthermore, under the Supremacy Clause, a federal agency may preempt state law only when and if it is acting within the scope of its congressionally delegated authority. So that's another limitation on the Supremacy Clause. A federal agency may preempt a state law, but only when and if it's acting within the scope of its congressionally delegated authority. So whatever it's doing to preempt any kind of state law, it must be done within the scope of its congressionally delegated authority. And that's footnote 25. For an agency literally has no power to act, let alone preempt the validity enacted legislation of a sovereign state, unless and until Congress confers power upon it. Under the Supremacy Clause, the federal agency acting within the scope of its congressionally delegated authority may render unenforceable state or local laws that are otherwise not inconsistent with federal laws. So, get this, under the Supremacy Clause, a federal agency acting within the scope of its congressionally delegated authority, which we saw here, and that relates to this case here too, or this footnote, may render unenforceable state or local laws that are otherwise not inconsistent with federal law. So, within, as long as it has congressionally delegated authority, it could a federal agency can still render state or local laws, unenforceable. That would normally be that are otherwise not inconsistent with federal law. So there's really no conflict. So this wouldn't be preemption by conflict. This would be preemption by a federal agency acting within the scope, and they find something that, for another reason, I guess, or could be for that, but they find some reason that is otherwise, it's not inconsistent with federal law, but they find it unenforceable, or they render it unenforceable because of some other reason, which we could look in deeper if we want to know the details with footnote 27. So let's get to this really quick here. Make sure we're still online here. Yeah, looks like we're still going good. Okay, so here's the great part here, the cumulative supplement in cases. So here's a good one. So when a federal agency determines that a contractor meets some federal contractor procurement qualification set by Congress, a state agency may not, under conflict preemption principles, exercise its authority and impose additional state law qualifications that stand as an obstacle to that federal agency determination, and more specifically, to the qualifications set by Congress. Nice. So that's Metro Tri-State Incorporated versus a Public Service Commission of West Virginia, 2021. So this is a very recent case here. Just want to make sure everyone's still here. And we get everything happening here on the YouTube end. Beautiful. Looks like we're still hanging in there. And we're going to sum it up now. So this is a very interesting case here. So a federal agency determines that a contractor meets some federal contractor procurement qualification set by Congress, and some state agency wants to impose additional qualifications under state law. It could be an obstacle to that federal agency's determination, final decision, right? And more specifically, to the qualifications set by Congress. So you can't add to qualifications set by Congress, and you can't reduce it either. That's what that gets to here, and that's the case here in 2021, just recently decided. So we had a few, some more railroad stuff in here. We saw 20 and 21 we want to look at here. Clearwater. Oh, nice. That's in Florida, 11th Circuit. And for purposes of the Supremacy Clause, the constitutionality of local ordinances analyzed in the same way as that of statewide laws. And that's Hillsborough County, Florida versus Automated Medical Laboratories Incorporated. Interesting, 1985. And then we had another one, was 24, Public Utilities. Is it appropriate to expect of federal administrative regulations to declare any intention to preempt a state law with some specificity, That's a tongue twister there, huh? With some specificity. Because agencies normally address problems in a detailed manner and can speak through a variety of means. If a federal agency does not speak to the question of preemption, the United States Supreme Court will pause before saying that the mere volume and complexity of the agency's regulations indicate that the agency did in fact intend to preempt state law. So this is saying that you need to specify exactly that you plan to preempt a state law with specificity, because normally these problems are addressed in that kind of a detailed manner and can speak to a variety of means. So if a federal agency does not speak to the question of preemption in a specific manner to the law specifically, the United States Supreme Court will pause before saying that the mere volume and complexity of an agency's regulations indicate that the agency did in fact preempt state law. And 27, we have Reed versus Johnson & Johnson, 2015. All right, and I think we could leave off on the supremacy of treaties, because now we're going to get off into the foreign land arguments that might go beyond the scope of our audience. So on that note, I really want to thank everyone for attending tonight. We had a great session, I believe, of going over the constitutional law and the supremacy of the United States Constitution and its amendments, how it applies to both the local municipalities as well as state laws, and that understanding the way the courts rule on these matters, the way the states are supposed to consider the federal rules that might conflict, and the lack of authority for states to impose additional qualifications and such on federal regulations. So with all that said, I would like to again say thank you for everyone for spending your time here.